We're going to get started. Good morning, good morning, good morning. Here we are, gathered in the room filled with the soft light of new beginnings. My name is Ecclesiastes, and I serve as the editor-in-chief of the University of Pennsylvania Law Review. Our meeting today carries a weight of history and promise, and this is because we have the honor of presenting Volume 172 Symposium, Statutory Foreign Affairs Presidency. But our story does not begin in the modern day, but back in 1852. Picture, if you will, the cobblestone streets of Philadelphia, the clang of the blacksmith, the murmur of the crowds. In this setting, two visionaries, Asa Fish and Henry Wharton, gave birth to the American Law Register. Fast forward to 1908, and that modest initiative had transformed into our present entity, the University of Pennsylvania Law Review. I note with a touch of playful pride that our longevity might be a point of good-natured contention among esteemed colleagues at Harvard, Columbia, and Yale. Our pages have witnessed monumental stories, the profound significance of the 14th Amendment, the valiant pursuit of civil rights, and our uncharted venture into the digital age. It was over 4 decades ago, during the tenure of Volume 130, that this symposium tradition was inaugurated. Its inception was simple: a bond of respect and a shared vision between the burgeoning talents of Penn Law and its faculty. Over the years, our discussions have spanned a vast intellectual landscape, each topic shedding light on the pressing issues of its day. Today promises yet another enriching chapter. Esteemed scholars will share insight that will eventually find a home in 9 comprehensive articles with a special piece slated for the University of Pennsylvania Law Review online. In closing this introduction, my heart swells with gratitude for all who've made today possible, our supporters, colleagues, and every individual present. To Arnold and Porter and Morrison Forrester, thank you for your unwavering belief and support in making this event happen. A nod of appreciation to Dean Sophia Lee, Dimitri Islam and Student Affairs, and all who worked tirelessly behind the scenes to make this event happen. Thank you, Professor Goldsmith and Bradley, and our panelists today for engaging in this scholarship and this legal thought. I want to thank Volume 172 Symposium editor Jonathan for his steadfast dedication to making this event possible. Volume 172's managing editor Michael Crone for his logistical guidance and planning, and Law Review's administrative coordinator Ralph Mullen for dotting all our I's and crossing all our T's. The heartbeat of our publication, as many of you know, resides not just within its pages, but in the hands of those who craft it. I would also like to give a heartfelt nod to the editors of the University of Pennsylvania Law Review. Their dedication, the precision of their edits, and their consistent contributions cannot be praised enough. Their fingerprints are on every page, every idea. Turning my gaze to this room, I see familiar faces, new acquaintances, and champions of legal thought. Your presence elevates our discussion, deepens our discourse, and I voice not just my sentiment, but the collective gratitude of our journal when I say your participation in today's discussion is truly cherished. Now, without further reflection on the past, let's embrace the present and the future. I'm honored to introduce Dean and Bernard G. Segal Professor of Law, Sophia Lee, to share her welcome. Let our discussion today be insightful, engaging, and memorable. Thank you all.
Well, thank you, Ecclesiaste, for this very kind introduction and wonderful overview of the history of the Law Review, and just more generally for your incredible leadership of the Law Review over this last year, especially when I was also asking you to be a TA in administrative law and add to that burden. I also want to especially thank Jonathan Wiersema, who, as we just heard, was an organizer for this symposium. And I should add, relevant to the topic of today's symposium, is also one of the law school's Jessup International Moot Court stars. I'm also just thrilled to welcome all of you here to the 2023 Law Review Symposium. So this symposium centers on the core question of the relationships between Congress and the President and the executive branch more generally in the conduct of U.S. foreign relations. You're going to hear panels today that engage with different substantive areas, including trade, national security, and human rights. You're also going to hear discussion of some hard questions about the distribution of power between and among the branches. To what extent does the President have exclusive powers over diplomacy or other aspects of foreign affairs, such that Congress just can't regulate in those spaces at all? When Congress can regulate and does delegate power to the executive branch via statute, how precise do Congress's directions to the executive branch have to be? Where the courts set that precision requirement can determine whether they will find a statute's delegation unconstitutionally broad. For any first years in the room who have not yet had con law or administrative law, this is called the non-delegation doctrine. Courts' precision requirements can also determine whether they're going to interpret a statute narrowly under what's called the major questions doctrine. Also, and I think particularly pertinent to today's topic, should those precision requirements be more relaxed in foreign affairs, given the President's special powers and competencies in that sphere? And a question that I've had in teaching these doctrines is what the consequences will be for our conception of foreign affairs if it becomes a more powerful escape hatch for the executive branch from the court's newly robust precision requirements. One can certainly imagine strong hydraulic pressure to expand that concept of foreign affairs in ways that seek to sweep an increasing swath of traditionally domestic policy within it. And of course, these are also incredibly timely questions at a moment when Congress is paralyzed, even as the demands on the US abroad are escalating. So you're in for a very rich discussion and a lot of really important conversations today. Now, among the many exciting things about our Law Review Symposium is that it gives our students the opportunity to work with leading scholars across the country as they explore these cutting-edge themes. And we have an extraordinary group of foreign relations law scholars here today. Now, these include people who have practiced in the State Department, the White House, the Office of the U.S. Trade Representative, and elsewhere. And you'll hear from some leading practitioners at lunchtime, along with the estimable Judge Diane Wood of the Seventh Circuit. And one thing that's also distinctive about our Law Review Symposium is that it not only brings together scholars from across the country, it also gives our students the chance to work with faculty at other institutions in designing the symposium. And in that vein, I'm delighted to introduce Curtis Bradley, who is one of the symposium co-organizers, along with Jack Goldsmith. And I believe he is going to do the introducing of Jack Goldsmith. So which is good, because once you hear how much it takes to introduce Curtis Bradley, you can imagine that having just him to introduce is quite enough. So Professor Bradley is the Alan M. Singer Professor at the University of Chicago Law School. He's a leading scholar in foreign relations law and is astoundingly prolific and influential. If I were to list all his articles and books, I think it would take the entire time allotted for his full panel, so I'm not going to do that. I'm just going to give you a few summary highlights. So he's the author of a leading casebook in foreign relations law, of 4 other books or casebooks, and 4 edited volumes. That's just one highlight. He's also the author of too many articles to count, but I think it includes well over 50 substantial articles as well as many smaller ones. Many of those have been co-authored with other participants in this symposium today, including a forthcoming article in the University of Chicago Law Review that he co-authored with Jack Goldsmith and Una Hathaway about the rise of non-binding international agreements. He's also a leader in the developing field of comparative foreign relations law. He received a prestigious Carnegie Fellowship that led to his edited volume on the Oxford Handbook of Comparative Foreign Relations Law. He's also the former editor-in-chief of the American Journal of International Law and one of the reporters on the Restatement Fourth of Foreign Relations Law of the United States. And amid all that, he is also known within the field as a strong mentor to junior scholars. So any budding legal academics out there, I encourage you to take a moment to get to know him today. And he's also known as someone who is always on the lookout for interesting new research and ideas, and who relishes engagement with people whose views differ from his own. So with that, I will turn it over to Professor Bradley and leave him the equally daunting task of introducing Jack Goldsmith.
Thank you for the introduction. I appreciate that. I won't say a lot about Jack. We'll hear from my co-organizer, Jack Goldsmith, throughout the day. And the way we've divided it up is I will say a few remarks just to get us started, and then Jack he's actually going to moderate our lunch discussion, which I'll say something about, and also give a few concluding remarks near the end of the day. The topic, as you've heard, is the Statutory Foreign Affairs Presidency. Jack and I want to begin, before I say a little bit about the substance, just to thank the students of the Pennsylvania Law Review who've done basically all the logistical work and helped have this come together. Particularly Jonathan, where some of you probably, those who are participating, have had many emails from him all the way up until the wee hours of last night, probably. It takes a lot of work. Having run many conferences myself, I know how much work it takes, and the students have just done an incredible job of pulling this all together and handling all the details that need to be addressed. Of course, Jack and I want to thank the Law Review also for picking our proposed topic. And we felt very strongly that this was a timely and important topic, and we were thrilled that the Law Review ended up agreeing with our enthusiasm with respect to this topic. And I want to take the time to thank all the presenters and commenters and moderators and lunch speakers you'll hear from today, many of whom traveled here, and I don't take that for granted. It's always a burden to come and attend something, and we really appreciate their attendance, and many of them have written draft papers already, which I've enjoyed reading. So thank you for doing that, and thanks everybody for attending, both here and I know some people may be online. So a little bit about the substance before we have our first panel. The focus is on the connection between statutes that Congress enacts and executive authority as it relates to the conduct of foreign affairs. So those who follow the scholarship in this area with respect to executive power will know that most of that work traditionally has focused on constitutional law. That is, questions are about whether the president has the power to take the U.S. to war, for example, without going to Congress first. Just a mountain of scholarship on that topic alone. The predominant focus has been on Article 2 of the Constitution and what to read into phrases like the executive power. Important topics, but by predominantly focusing on just the constitutional law side, Jack and I thought that we were missing probably what most of the action is with respect to executive action in the modern age, which is the connection between what presidents and more generally the executive branch do and statutory law. And in fact, the modern reality, partly because we've had a proliferation of statutes and administrative regulations, is that most important things that presidents do in foreign affairs, even in the midst of crises, are connected in some way to statutes. I could give you a very long list. I'll just give you a couple of examples. The crisis in Ukraine, Russia's invasion of Ukraine, requires, or at least is thought to require, a presidential response and action. And President Biden has taken numerous actions to promote U.S. foreign policy goals in connection with that conflict, almost all of which have connections to statutory law, whether they be sanctions, supplying armaments, and many other steps. Think about U.S. relations with China, both in this administration and the last, including economic competition and sanctions, all connected to statutory law. Go further back in time and think about the so-called war on terror after the 9/11 attacks. connected, if you think about military commissions, detentions, use of predator drones and the like. There are constitutional issues, to be sure, but there are also important framework statutes that have guided many actors, including the courts. If you look at the Supreme Court decisions, all the way back to decisions like Hamdi, they're framed in terms of statutory law. And this is even a more long-standing phenomenon, if you think about how the United States engages with other countries and makes agreements, makes binding commitments, you might think, if you just glanced at the text of the Constitution, that we're mainly talking about the Senate and getting 2/3 of the senators present to agree. Well, it turns out that's not the case. Very few international agreements go to the Senate anymore. That's its own topic. You'll hear a little bit about that later today. Most international agreements are, in fact, authorized by statutes. And then there are debates about whether those statutes, in fact, authorize the agreements and what they authorize and the like. And there are many, many examples, like the ones I've given, that show how a lot of our foreign affairs actions are really grounded, at least in part, in arguments about statutes. And that means that the focus should be, at least in part, on issues of congressional authority, as opposed to just executive authority, issues about delegation of that authority from Congress to other actors, issues about statutory interpretation, since we do have these statutes to work with, and issues of administrative law, because they, of course, are carried out in many respects, not just by the president alone, but by a large executive branch with many agencies and departments. And these principles will have a big role to play in how the law is shaped. Now, not coincidentally, certainly it influenced our suggestion of this topic. Our Supreme Court has been focused on many of these statutory issues in the domestic realm in recent years, focusing on issues of a possible revival of the so-called non-delegation doctrine. That'll come up in our first panel. They have developed, with lots of academic commentary surrounding it, a so-called major questions doctrine to affect the way they interpret certain statutory grants of authority. They're considering what to do about the so-called Chevron doctrine, about a deference to administrative agencies on statutory interpretation. So this is a very dynamic area of the law in the domestic arena, and the focus of this conference is the relevance of all of that when one thinks about foreign affairs. There are 4 panels today to address that general topic. I'll just mention what they are. One, we're going to talk first about general issues of delegation as they relate to foreign affairs. Second, we're going to talk about executive action specifically relating to statutes in the areas of trade and commerce and sanctions, a very big part of U.S. foreign policy today. Third, we're going to focus on the conclusion of international agreements, as I've already mentioned, and somewhat relatedly, and I do think related, is more generally the disaggregated nature of the executive branch in conducting foreign affairs. It has been commonplace in a lot of literature to talk as if foreign affairs are just conducted by the president or conducted in a unitary way. I have had the privilege of working in the executive branch, as have a number of people in this conference. One thing you immediately learn is it's not exactly unitary when you work in the executive branch, and we'll talk more about what that looks like in the foreign affairs arena today. And then we're going to focus on issues specifically about national security and individual rights. We also have, very lucky to have, a keynote lunch discussion today. Jack and I were just thrilled to be able to persuade people we know to participate in this. You'll hear from them at lunch, and as you'll see, we have representatives with experience in all 3 branches of the federal government, in Congress, the executive branch, and the courts. And so in addition to hearing academic perspectives today, you'll also hear from people who really have practical connections to a lot of what we're discussing. So I'm very excited. I hope you are. I am obligated or asked to read a statement. This will maybe not be the most interesting thing we do today, but about CLE credit. So people do care about this. If you are seeking credit for this, CLE credit, please note these CLE passwords are going to be announced, I guess, twice per hour. write them down and enter them. Apparently there's some digital evaluation form once the event is over, and you have to do that to get the CLE credits. And I think there's been a link sent to you, an email form for that. And if you didn't get it, you'll find it in the Zoom chat or the QR code around the auditorium. And the passwords apparently tell them how long you were able to attend. So that's the gist of our conference. I'm excited. Thanks again to the Law Review students for helping organize this and for selecting what I hope you will agree is an important and timely topic. And we're now going to turn to our first panel. Thanks.